This is in continuation of our earlier discussion on the sole trader organization. Now, today I am going to discuss about the partnership form of organization. As you are aware by now that sole traders have limited financial resources, limited managerial abilities and skills, and limited liabilities. Therefore, expansion of business becomes difficult for the sole trader. He may need more capital, he may need more managerial skills, etc., etc. Therefore, two or more persons come together, they join hand together, and they form the partnership form of organization. When you see the definition of the partnership form of organization, it says that a partnership is a form of business organization in which two or more persons, it says that up to the 50, they join hand together to undertake some form of business activity. If you see the definition of the Indian Partnership Act 1932, which defines partnership as the relation between persons who have agreed to share the profits of business carried on by all or any of them acting for all. Next is about partnership is an association of two or more persons who have joined together to share the profits of business carried on by all or any of them acting for all. If you analyze this definition, then you will come to know that there are four important components of this definition. First is relationship. That means this is a relationship between two or more than two persons. Second is agreement. This relationship depends on particular agreement for which the partners they come together and they decide to carry on some business. Third is sharing profit or loss. The partnership business is carried out for the purpose of sharing the profit or loss among the partners. Next is carried out by all or any one of them. You should remember that the partnership business may be carried out by all partners, or one or two partners may carry out partnership business on behalf of all other partners. Now you have understood the definition of the partnership. Let us see the main features of partnership. The first feature of partnership is plurality of persons. As you know that there must be at least two persons in the partnership, and the maximum limit is 50 persons as per Companies Act 2013. Next, contractual relationship. As you are aware that the partnership is created by an agreement among the partners, and this agreement becomes the basis of the contract. That is, once partners agrees on that, in that case it becomes the contract, and this contract can be oral, written, or implied. Therefore, the partnership has contractual relationship. Next is profit sharing. See, the agreement among the partners are to share the profit and loss which comes from the partnership business. So, therefore, more persons they jointly carry out the business and they share the profit and loss. Here it must be clear to you that sometimes more than two persons may have joint property and they may share the income of that property, but it will not called partnership. Next is existence of business. In order to carry out the business under the partnership, you must have some lawful business for which you may share the profit. For example, two or more persons come together and they are planning to have robbery of the bank. This is not the partnership because there is no legal business here. In the same way, sometimes you may work for the charitable purposes. Again here, it may not be treated as partnership. Next is principal-agent relations. See, it must be clear to you that in the partnership business, the business is carried out by one or two person or by the whole partner, all the partners. If the business is carried out one or two persons, he is the representative of the business. That means there is a principal-agent relationship in the partnership because each partner is entitled to represent the firm and other partners in respect of business of the firm. So, all partners are bound by his acts which has been carried out to run the business. So, therefore, the partner is an agent of the firm and the other partners as well. Next is unlimited liability. See, if there is a debt on the business, each partner has unlimited liability because if the assets of the firms are not sufficient to meet the obligations of the firm, the partners are liable to pay from their own private assets. That means all the partners are liable for all business debts and obligations. Next is good faith and honesty. You all must be knowing that agreement rests on good faith among the partners. Therefore, the partners should be honest to each other. They must trust each other. If there is any information, they must disclose that information among the partners. If there is any accounts and all that to be shared among the partners, they must do that. Next is restriction on transfer of share. A partner cannot transfer his share to the outsider without the consent of all other partners. So with these features, let us now see the classification of partners. You all know that in the partnership firm, some partner may contribute more capital, Some partner may contribute more what is called skills, some partner may be more professionals, etc., etc. Therefore, the partnership may be or partners may be classified on the following basis. The first is based on the extent of participation. Based on the extent of the participation, the partnership may be active, there may be active partner and sleeping partner. As the name suggests, active partners takes active part in all business activities. Therefore, he is known as active partner. He is also known as working partner because he participates in the most of the activities of business and he is very active in the activities. Second may be sleeping partner. Some of the partner, they do not work that much actively. Therefore, he is known as sleeping partner. The sleeping partner, what he does, he simply invests capital in the business. He does not participate in all activities. Therefore, he is also known as dormant partner. The second classification is based on the sharing of profits. Based on the sharing of profits, the partner may be nominal partner or partner in profits. If the partner just lends his name in the partnership, he is known as nominal partner. You should consider here that he neither invests his capital nor he is participating in day-to-day activities of the business. And such partners are not entitled to a share of profits, but you should know that such partner, he or she is liable to other parties for all the acts of the firm. Second is partner in profits. There may be partner who shares the profits of the business and he is not liable for losses, and such partner is called partner in profits. He will not take any part in the management of business. This may be applicable to the minors who is admitted to the business for the benefit of the firm. So, he is called partner in profits. Next is based on the behavior and conduct of the partner. Accordingly, there may be two again types of the partner. One is about partner by estoppel and another may be partners by holding out. You should understand both the concept very seriously. As far as partner by estoppel is concerned, a person who behaves in the public in such a fashion that gives the impression that he is one of the partner of the partnership firm. Try to understand it. The person, he gives the impression in the public that he is the partner of the firm. Such partner is known as partner by estoppel. Such partners are not entitled to profits, but such partners are fully liable as far as the debt or other obligations of the firm are concerned. Second is partners by holding out. If a particular partner of a firm, he represents that another person is the partner of the firm, and the another person, he does not contradict this even if he comes to know about this fact that somebody is representing this person as a partner of the firm. He is called partner by holding out. Such partners are not entitled to profits, but they are liable to obligations of the firm. Next is based on liabilities. Based on liability, there may be limited partner and general partner. When the liability of the partner is limited to the extent of the capital which is contributed by him, it is called limited partner. You must take care that such partner is not entitled to take part in the managerial activities or in the management of business. He can advise, but his advice may or may not be binding to the firm. Such partner is also known as a special partner, and such partner has the right to inspect the books of the firm also. As far as general partner is concerned, his liability is unlimited and he is entitled to participate in the management of the business. That means the partner who is not limited partner, he is the general partner. After the classification of the partners, let us come to the merits and limitations of the partnership. The merits involves the first stage, EG formation. As you all know, as you must be knowing that the formation of the partnership EG, because it depends on the agreement which has been signed among the partner. So it is not much difficult than that of the company. What happens here? The partners, they come together, they agree, they draw up the whatever that activities are there, they sign it and it becomes the partnership agreement, and there is no complex government laws which regulates this. Next is more capital available. Because there are two or more persons involved in the partnership, therefore you can have added financial mobilization capacity. Because there are more persons, so there may be more funds, and even you may have the funds from bank or other places more because you have more financial strength among the partners. Next is more diverse skills and expertise, because more people are involved in the decision making. Therefore, there are more than two minds here which come together, they apply their mind. Somebody may be a specialist in manufacturing, somebody may be a specialist in marketing, in production, in service, etc., etc. Therefore, there would be a combined judgment here. Once there is a combined judgment, then probability is that judgment would be better for the running of your business. Next is flexibility. The partnership business is owned and run by partners themselves. So they can come together, they can appreciate quickly, they can respond quickly to the changing conditions than that of the company, because the larger director and all that are involved here. So comparatively there is a flexibility in partnership. Next is secrecy. The partnership firm may maintain secrecy because they are not obliged to publish accounts of the firm. Next is keen interest. All the partners may be liable for the profit and losses. Therefore, the partners may make their best effort to do better in the business. Next is protection. As you all know that if the partner is dissatisfied with the working of the firm, he may ask for the dissolution of the firm, or he may withdraw from the business. Next is checks and controls over careless decisions. Since the partnership is run on collective basis, that means all the partners are associated with the major decisions of the firm. As a result, you have a combined decisions and you do not take the reckless or hasty decisions. Next is diffusion of risk, because it is shared by all the partners. So if there is any loss, that would be shared by all the partners. That means the risk is being diffused among the partners. Let us learn the limitations of the partnership. The first limitation is limited capital. Obviously, the maximum limit is 50. Once the maximum limit is 50, so obviously that much is the limitation of mobilization of the firm. Next is unlimited liability. Obviously, all the liabilities or debt are being borne by the partners himself. Therefore, it is unlimited liabilities for the partners. Next is no public confidence. Obviously, the accounts of the partnership firm is not published. Therefore, the public do not come to know. As a result, there may be less confidence about the partnership firm among the public. Next is non-transferability of interest. No partner can transfer his interest of the firm without the consent of other partner. That means if you want to transfer your interest, obviously you need the consent of all the other partners. Next is uncertainty. As you must be knowing that there must be sudden death, lunacy or insolvency of the partners. If such death or insolvency comes into the picture, obviously that may lead to dissolution of partnership. As a result, this creates uncertainty in the continuity of partnership firm. Next is conflicts among partners. As you all know that the maximum limit is 50. So in that case, there may be misunderstanding, miscommunication among the partners, and if that prevails, there may be delay in decision making, and which may ultimately lead to the dissolution of the firm also. Next is risk of implied authority. As you all know that the partner is agent of the partnership firm also, and he acts on behalf of all the partners. Therefore, sometimes if one partner is dishonest or incompetent partner, that may create again big problem for the partnership firm, because he may create huge problem which may be very, very complex. Therefore, there is a risk of implied authority among the partnership firm. So now you have understood about the partnership classification, features, merits and limitation of partners. Thank you.